Great. Thanks, Teresa. This is Winston. For everybody that is joining us, thank you very much. I know this is the first two webinars are going to be on the longer side, so thanks for joining us on your busy Fridays. I just want to quickly highlight the importance of this material, our partnership with the Licensing Executive Society, and finally, I want to thank our generous sponsor, Steptoe Johnson, and they were generous enough to help offset some of the costs of producing this content and curriculum. So in the past 6 months, we've had a lot of experience with finalists from our first ever National Clean Energy Business Competition for students, both with the teams in our own region, and we've been able to observe teams nationally. Questions about licensing and IP have come up throughout and have been very significant, and in some cases very consequential to the development of the team's business plans and technologies. So over the past couple of months, we've been working with LES to try to reform some of their content to support this Clean Energy Challenge. This is the first time they've done a virtual webinar like this, so bear with us for any of the logistical constraints that we might have to deal with in order to make this work. Again, I'd like to thank Tom Filarski, who is an advisor to Clean Energy Trust, and his firm Steptoe Johnson for sponsoring this material. If you guys find it valuable and rewarding, again, we'll have it posted online, both on the LES site as well as the Clean Energy Exchange with all the other webinar curriculum.
Great. Thank you very much. I would like to introduce Jeff Whittle today, LES of USA, Canada, and the Vice President of Education. It's all yours, Jeff.
Thank you so much, Teresa. Welcome, everybody, to the IP and Licensing Basics, sponsored by LES and Steptoe Johnson. We're excited to have you, and we're just thrilled that you're interested, and we hope you will glean a lot of valuable information from this webinar. It's a 2-day review of material on IP and licensing basics that we think you will enjoy. It's been material that's been used many times, and we look forward to engaging you in this whole process. I will be attending the seminars or the webinar throughout the whole process, so welcome questions direct to me or through LES, and we'll be glad to field these and keep the teams and the instruction process moving as effectively as we can. Through this process, we have a business professional with us, which is the outstanding Linda Chow from Stanford University, who has extensive experience in university licensing. And I think you'll find the second session that she teaches or instructs on will be valuable and outstanding. And we also have the one and only, the man himself, Tom Filarski, the partner with Steptoe & Johnson, who is a legend in licensing and IP litigation. And I think you'll find him to be outstanding as well. He's the former president of LES, U.S. and Canada, and we're privileged to have him with us today. So thank you, Tom. For the course program, today we'll have the intellectual property basics for an hour, and then basics of IP commercialization. It's a 2-hour program, as Winston mentioned. And then next week we'll follow with the determining reasonable license fee and royalty rates and managing licensing risk. We'll do an introduction to negotiation and licensing game on March 1st. And on March 15th, we will have the licensing game debrief and allow the teams to negotiate in the process. And before we get started, and before I turn it over to Tom, I'd like to ask each of you a few questions, if you would, please. And as I ask you the question, I'd like you to respond. We're just doing a poll here for those attending. And the first question is, the following best describes my current position. I'll repeat the question one more time. It is, the following best describes my current position. So please take a moment to answer the poll. Super. Great job. And Teresa, can you do the second question? I seem to have lost control there on the second one.
Absolutely. And the second question is, regarding my experience with IP, and you have your 4 options that you now see on your screen.
And then we can go ahead and ask them one more, Teresa, if you don't mind.
Absolutely. We'll just give them a few more seconds on this one.
Okay.
Thank you all for taking the time to answer this for us. Great. And our last question we do have today, my level of experience with licensing IP. If everyone could just take a second to answer that as well. Great. Great. Thank you all very much for taking the time to answer that. We actually have a 50-50 split there for you, Jeff.
Oh, wonderful. Thank you. Thank you all for taking your time on that. Before we get started, also, I'd just like to acknowledge, thank those who wrote the program, wrote the material, and are responsible for initiating that. That's on the next slide, which is Alan Lewis with the Atoms and Atoms out of South Africa, which the LES USA and Canada has a license and has modified to enhance for these jurisdictions in the U.S. and Canada. We also want to thank Jim Vlasny for his valuable contributions, as well as Wally Oliver. The Licensing Executive Society is an independent professional organization that promotes and facilitates global intellectual property commerce through education and networking. It has approximately 5,000 members in the business and licensing, lawyers, consultants, technologists, academics, and government officials. And we hope that you'll value your membership in LES and be active and involved, and hope you get outstanding value out of the program. Now I'll turn it over to Tom. Tom, would you like to take it from here, please?
Thank you, Jeff. I very much appreciate that wonderful introduction. I don't think I've achieved legend status, though. But I do want to recognize you and Linda Chow, who we all will meet later. I've been serving with the both of you on the LES board for quite a while now, and you both do a wonderful job in advancing licensing and what we do. So thank you for taking your time. What I want to do right now is talk to you about IP. So the first slide you see here is the awareness and value of IP. And no less than Bill Gates and Warren Buffett recognize that licensing and licensing of innovation is what drives growth, and they recognize the difference between IP, which are intangible assets, and real property, things like machine manufacturing equipment and buildings are tangible assets, and that one must be skillful in managing both of those assets. And that's important to whether it's a new company or a startup company or some company that's been around for 100 years. And so what we want to speak to you about today in session 1 is IP and licensing basics. And so there's the usual disclaimer that what I say doesn't relate to any of my professional activities as far as my firm is concerned. But and there is no legal advice being rendered to you. It's just for information purposes. But let me start out, first of all, by saying if anybody has any questions, we are trying to monitor that. If you type them in, Teresa will assist me in trying to respond to your questions throughout the presentation. There also will be a question and answer period at the end of the presentation, so feel free to type in your questions, and we'll try to get to them on a timely basis. So I guess one way to start out is to do a little exercise and ask you to think about where is the IP in this article. That's a glass, what appears to be iced tea, and there is a sugar molecule. For those who are chemists, we gave the formula there, the structured formula. But there's IP contained in this. And what type of IP are we speaking about? Well, there's different types of sweeteners that could satisfy the need for the person who wants a sweetener in there. There's sugar, of course. There's also aspartame or equal. There's Splenda, products you know about or may have heard about. Sweet and low, which is saccharin. And then, of course, there's a brown sugar in the raw. That's brown sugar. And then there's domino sugar. So there's different types of sweeteners here. And there's different ways to protect these trademarks. Protect this IP. So what kind of IP are we talking about? Well, there's obviously patents, and the different molecules at the top can be protected by patents, whether it's aspartame or sucralose or saccharin. These are synthetic molecules that were invented along the time, along the ages, and have been shown to be used for sweetening attributes. But also, if you look at the packages below, there's trademarks, copyrights involved. There may be trade dress involved, and the trade dress would be the pink color, the yellow color, the white and blue color, things that people recognize. There may be trade secrets involved in the manufacturing of these items. Know-how, which is something I'll introduce to you, but and also there's design patents that may be involved. So there's a lot of IP that can be packaged into one product. And after today, hopefully you'll have a feel for the different types of intellectual property that go into bringing the development of a product and bringing it to the marketplace. So one thing people talk about is technology, and what is technology? And I think the best way to explain it is it's in the eyes of the beholder. And we have here just a slide that gives you a different feel for it. And there is no one definition, but there's a perspective. And so the scientists may look at it as an invention or know-how from the scientist's perspective. An engineer may say, well, no, the technology is more of a tool. Marketer may distinguish it as a competitive advantage. An attorney may say, oh, no, that's intellectual property. And a business person says, no, it's just an asset that I use to leverage. But keep in mind when you're dealing with technology that there are many different definitions. And I guess here's another definition that we can provide for you, and you can read that for yourself. And then in red there is Thomas Edison at the bottom saying, anything that won't sell, I don't want to invent. So that's a business/technical hybrid definition of invention. So for many years, what's important here is that regardless of the definition of technology, it's something that we want to protect because it has commercial value. So let's talk about IP in general, and I've mentioned the different types of IP there, and you can see that on the graphic. But we're going to speak today first about patents, and then we're going to turn to trademarks and speak to trade dress, confidential information and trade secrets, designs, and then we're going to close with copyrights if we have some time. This session that I'm going to speak will be about 40 minutes or so, and then from now, and then Linda will take over for the concluding hours. So let's start with the basics of IP. As I mentioned, there's some of the IP that we talked about, and just to give you a feel for it, patents and copyrights and design patents and registered designs are generally created from statute. The United States has several statutes on the patent law, copyright, etc. And then trademarks and trade dress. Also, there are statutes that address that, but also those are created through use, and we'll talk about that a little bit. And then we turn to trade secrets and know-how. Those tend to be established by not only through conduct or use, but by contract as well. Not established, but protected by contract. So let me first speak about patents. So what are patents? Well, patents a patent is a right government or granted by the government to an inventor in return for disclosure of the invention that is patented. It's there's a Latin phrase called quid pro quo that is used, and basically what it is, it's vested in our United States Constitution, actually. The theory being that if one creates an invention, one is entitled to exclusivity to that invention for a certain period of time, and exclusivity meaning to prevent others from using that invention. And in exchange, that inventor should tell the world what it is that the invention is, how to make it, how to use it. Give enough information for people to practice that invention once that exclusivity period expires. And the theory goes that system will promote more innovation. In essence, if I create something and you see it in the public domain, you respect it, and when my rights expire, you think you can create a better something, you have a right to do that. Or if you see it, you can design around it and create a better mousetrap, if you will. That is the promotion of innovation. That is the fundamental backdrop for the patent statute. So let me turn to what are the characteristics of the patent. Well, as I said, it protects inventions. It's territorial. So United States patents are limited to the territories of the United States. Canadian patents are limited to Canada. And Japan patents are limited to Japan, etc. So we'll talk a little bit more about that internationally, but you may have heard about the European Patent Office. That is somewhat limited to the European region of the countries that have joined the European the European region. But those countries, individual countries such as Germany, France, Spain, etc., and UK have also their own patent laws. The basic requirements, these are very, very basic requirements for patents, are one must invent. First. Second, the invention must be novel, and that means no one else has done it before. Third, it must have an inventive step, or in the legal vernacular of the United States, it must not be obvious. And that is a very difficult and complex concept, but it basically means when the person to whom the invention is addressed, known as a person skilled in the art, when that person views that invention in view of everything else known at the time, is it something that takes an inventive step, or is it something that's very obvious that one skilled in the art would see? There's many case decisions over the decades addressing that point, but that's the essence of the inventiveness or non-obviousness step. And then a final basic requirement is an adequate disclosure of the invention. That's the quid pro quo that I mentioned earlier, that as the inventor, one sits down and writes it up and explains what the invention is. I'm going to show you a couple patents down the road in a bit just to make this a bit more clear to you. Then there's a registration or examination process whereby in the United States, patent examiners at the patent office actually look at the application and negotiate back and forth. It's called a prosecution. It's more of a negotiation, if you will, but it's a formal process whereby the examiner will accept or reject the claim for a patent or for an invention. And then once that process is over and the examiner allows or approves of the claim for invention, the case or the patent is issued, and that turns into enforceable rights. So what may be patented? This actually is an interesting topic and somewhat of a hot topic today, but generally the law says any apparatus, device, article of manufacture, such as a formulation, one or more elements put together, a method of making or doing something, or a process, and a new composition of matter, such as a new molecule in the chemistry arts, can be patented. The types of things that cannot be patented are laws of nature, algorithms, and mathematical algorithms and mental processes. And to give you an example of a law of nature, there's a current case that many of you may have heard about. It's the Myriad case, and it's filed by the ACLU and it relates to an attempt by Myriad to patent what is characterized as the breast cancer gene. And the issues there are whether the isolation by Myriad of a series of proteins that are strongly correlated to incidences of breast cancer, whether the isolation of that series of proteins is an attempt to patent a law of nature. I won't get into the issues of that because it's a complex question, but if you Google or search the internet, you will find that it's in front of the Supreme Court of the United States, and we expect a decision on that within the next 6 months or so. Mathematical algorithms are things like Einstein's law equals mc squared. No one can patent that. And the mental process is actually impacting the diagnostics industry, where there have been some claims to collecting and noting, collecting information of a medical condition and noting it, but not really applying that knowledge in anywhere. And that is more of a mental process. Collecting data and not using it to do something else is often thought of as a mental process. So let me speak a little bit about patenting procedure. Patenting procedure really, it's getting more into the patent attorney's field, but if you are applying for a patent or think you will be, it's kind of good to have a feel for what kind of procedure you're going to go through. And so we say here at the top that we have moved from a first to invent to a first to file basis. That's really what that means is there is a new law that was just enacted last year, and it actually has parts of it have come into effect today, and a significant part will come into effect on March 16th next month of 2013. And basically, the U.S. law is moving into conformance and harmony with the rest of the world with respect to what is the priority date for a particular patent. What that means, the upshot of all of that means is when you make an invention, you should not hesitate to, if you think it's viable, to file it with the patent office. And that's the first to file rule as opposed to the first to invent rule. But in the end, what it means for today's patent practitioner as well as business person is that the United States is going to go through a transition period of at least 5 to probably 10 years of dealing with this system of moving from first to invent and first to file, and you should be aware of that. Moving down to one other thing, you may see in these slides a discussion of Canada and other countries. LES is an international society with over 30 different societies around the world. So when we present this, many times participants have a strong international interest or component. I'm going to focus this discussion more on U.S., but if you have any questions about international practice, we can take those at a later time. Sometimes you'll see mention of Canada and other international variances. But in the U.S., basically, you file what's called a provisional filing. You have that option, or you can go right to a non-provisional filing. The difference between the two has to do with different rights one may have, but basically both of those filings require an inventor, as I've been saying, to sit down with an attorney and write up a description of the invention and show some drawings if necessary, and file it with the United States Patent Office. As I mentioned, the examination of the claims of the Patent Office by the patent examiner ensues at some point. There may be rejections, and that is the examiner saying, I think you're claiming a bit too much here, and if you narrow these, then we may be okay. And then there's argument, positions pushed back by the inventor saying, no, I don't agree with you, or yes, you're right, or some sort of compromise, and finally a claim is allowed, hopefully, when there's a true invention. And then the patent is issued and is enforceable only after the patent is granted. So here on the screen is a picture of a typical patent. I think this is a robotics-related patent. And there's a lot of information on here, but I wanted to just orient you to what a patent looks like. A lot of information on the front here. mostly for administrative purposes. But quickly you can find out the number, which is important, on the upper right-hand corner, the title of the invention, who the inventors are, going down the left-hand side, a bunch of information about where it's classified, important information as well as to when the actual patent application was filed. That gives you and anybody assisting you, like an attorney or a business consultant, an idea as to what the art is that it pertains to, but what we call the prior art. Much of it is defined by the filing date. And then at the bottom left and over to the top right is a list of other references that the patent examiner considered in examining the application. And then below that, there's a list of people involved, the examiner and sometimes the attorney. And then there's an abstract. And what that is a description of one version or one embodiment of the invention, but not the complete invention. So when you're reviewing these, never make the mistake of just reading the abstract and say, I understand the whole thing. What you do at best is you understand one embodiment of the invention. Next is just a selection of a little bit more of the patent document. On the left is, if it's mechanical-oriented, drawings. Plenty of drawings are used with numbers to describe how it works. And on the right is what we call the specification. And what that is the description of the invention that I've been mentioning. It basically talks about, here's the background of the invention, here's the area of technology, and here's what I think my invention is, and here's how I go about doing it, and I describe it, and here's how I make it, here's how I use it, and here's how I can enable others to make and use my invention. Just patents have columns on left and right, 1, 2, 3, 4, etc., and then there's a numbers sequence down the middle, and many people will say, well, go look at column 1, line 30 or so, and you can go and look at the text and talk about it or discuss it as needed. At the end of the document is something called a patent claim, and this is important because this patent claim truly defines the property right that we're speaking about, and it's the right to exclude others. And this is an important concept, that the claims are truly the definers of the right that an inventor holds. So a patent claim has been described as a fence, and I think it's a decent analogy to consider, at least especially if it's your first time to really start thinking about patents. But I'm talking about a fence in a backyard, let's say. You go home and go outside and you have a fence, and that fence roughly defines the boundaries of your property. And what that fence is a physical exclusion and an announcement to others that you cannot come into or cross this fence without my permission, without authority. So what a claim can be thought about is a boundary in words of what your invention is. And let me just show you, this is the set of claims. These are numbered paragraphs, starting with 1, going up to how many one needs to describe the invention. And this claim, if you read this, and any claim, it is one sentence actually, and it just goes on and describes the different elements that are needed to set out what the invention is. And these words form a fence, if you will, that defines the right of the invention. And any person who creates something subsequent to this and falls into this fence will be practicing that without authority. And this is the essence of licensing. Licensing allows others to practice my invention by allowing you, in exchange for consideration of some sort, to practice my invention or under this patent, come inside my fence, if you will, and practice it. And in that way, licensing promotes innovation out into the marketplace. Let's say I'm an inventor, and I have the ability to invent, but I don't have the ability to manufacture because I don't have the funds. So I license my invention to a manufacturer, and that manufacturer, in exchange for the license, pays a royalty rate of X% of the product that the manufacturer makes and sells to the public. In that way, innovation is brought to the marketplace. Let's see, going to the next slide, patent rights. I already spoke to this a little bit. So patent rights do exclude others from practicing, and it's considered a negative right, but as I described, it's really a right. It's a right to exclude others for a particular period of time so that the inventor can enjoy the benefits of his or her invention, but it also is the fundamental basis of licensing, at least of patents. I mentioned a little bit internationalization of patents, international patents. In general, if you come across this, there's a couple of concepts to be aware of. One, as I mentioned, is all patents are territorial around the world. There are many, many treaties that govern how these patents can relate to one another. One of the most important ones is the Patent Cooperation Treaty, also known as a PCT. It's really a vehicle for the different patent systems around the world to work together, and most major industrial countries are a member of the PCT system. There's also regional systems. I mentioned one. The most popular one is the European Patent Office, and that is a patent grant, but that's a complex arrangement of the European countries who participate in the EPO and to grant certain rights. So I don't want to belabor the complexities of these, but please be aware that the patent system in the United States is connected procedurally through the PCT and EPO and other systems so that one can enjoy patent protection not only in the United States for an invention made here, but also protect that same invention around the world. So one question is, should I patent or should I not patent? And there are many things that go into that. It is a business decision. It is a decision by you, the owner of the company, and you weigh it against the pluses and minuses of patents versus some of the other intellectual property options that I will discuss. I can tell you in my experience that many companies who acquire technologies or product lines based on technology innovations, as well as venture capitalists, want to see the existence of some patent portfolio that covers that technology. And especially, one likes to see a patent or two that covers the commercial embodiment that is being offered and the value adds that commercial embodiment have, the distinguishing features that product has over its competition or potential competition. Most acquisitions do an inquiry as to whether there's patent protection pending or actually issued on that value add embodiment. It's also important down the road. You'll hear later on in other webinar series about intellectual property monetization. The fundamental principle behind that is a business spends several dollars to obtain a patent, and that has an asset value, a book value, if you will, what those attorney's fees and patent office fees were and draftsman's fees, and you can add all that up. But there's an additional value over that, and that is the potential to license, sell, or use that patent to leverage other business opportunities, and that is an intangible asset value that one can attach to a patent or a patent portfolio. And so that there's a monetization opportunity that you'll hear about in subsequent webinar series, so keep that in mind as well. That's all I have to say about patents, and I want to now turn to trade secrets. And trade secrets is closely related to patents, except that this is not, a trade secret is not something that one needs to apply to the United States for. Instead, a trade secret is something that is not generally known by the public, and it has a value to the possessor of the trade secret, and usually that value gives it an advantage over its competitors. and the owner of the trade secret maintains the certain procedures to restrict access to that secret and keep it confidential. There are remedies under the laws that, if those basic fundamental concepts are met, that will protect the unauthorized use and acquisition of those trade secrets in order to protect the competitive advantage gained by the owner. Trade secrets are many times mixed in together with the concept of know-how. The concept of know-how is basically, I know how to do something better than anybody else, and I'm going to keep that secret. So sometimes those two phrases are intermixed. Here's some examples of trade secrets, and I'm sure you can think of more. Product formulations. I think maybe one of the most famous trade secrets is the formulation of Coca-Cola. It is said that that recipe does not exist in one space. Instead, the different components are protected in different areas of the company, and no one person knows the entire formula or recipe for Coca-Cola. But it is definitely something that is protected by trade secret. Manufacturing techniques, you can imagine, within a manufacturing plant, a certain way to run a certain machine is something that's known only to the operators and those who have studied it, and that's art form. Many times one may say, while it may be patentable, that the particular way of running a machine may be patentable, it's probably better for the company to keep it as a trade secret, and a company will choose that route for protecting that intellectual property. Engineering drawings and so forth, tolerances, when you're talking manufacturing again, sources of raw materials. Some people may discover that a particular quarry or a particular location in a country like China or maybe in Europe provides the best source of raw material for a particular process. That's a trade secret. Customer lists and source code as well fall into that category. Trademarks. Trademarks are a little different. Trademarks really talk about the protection of consumers. They protect consumers from being deceived. Trademarks are signs and logos and words associated with a particular good or service, and it's associated by the consumer. You could think of many trademarks. I'm going to show some of the examples. But when you see a trademark, you immediately in some way associate that mark to a brand, if you will, type of food maybe, or a service, and you may associate it in a positive or a negative manner, but the company's attempt is to associate it with its business services or products. And so you may choose one type of service over another based on its trademark because you've either had personal experience or you've had exposure to it through others, through advertising or through discussion with others, a reputation. And so you associate a certain level, service or good with that trademark. And that's something that is protectable. So like I said, it can be any sign or other indication capable of identifying a product or service and is used to associate products and distinguish products. And here's some examples of trademarks. It can be a device, a name, signature. There's no signature here, but I think those of you who have seen golf or magazines ads, Arnold Palmer has a distinctive signature, and he actually, I think one of them has an umbrella associated with it. And you associate that with a particular golf product. General Motors, IBM, Kodak, shapes and figures and colors. Colors at the bottom right. Think of the pink for Owens Corning fiberglass. That's a registered trademark, and one associates pink in the fiberglass industry with owning Owens Corning, particular type of insulation. So here's an example of what a trademark registration looks like. I just wanted to show this to you. This happens to be a shoe, and it's simply It simply shows what a drawing of what that mark is. And also, trademarks pertain to, must be associated with a particular class of goods or services. Trademark Office basically has a list of classes, pre-designated classes, and you can pick one or more classes to file or register a mark in association with that class. And it can be one or more classes. Here is another example of a mark, just for you to take a look at your leisure. So trademark rights, as I said, it's really to protect the consumers, but also it helps to build a brand associated with a product, which leads to, of course, greater revenue and better business. But trademark rights can be statutory or what we call common law. It may not be important for this discussion, but it's something to be aware of. One files for registration with the federal, under the federal law, and that gives you certain rights. But when one starts using a mark but has not registered, common law or state law, sometimes it can be state law or possibly federal common law, comes into effect to protect in a limited way those rights. So generally people urge, especially when you want to associate a mark with a particular product, it's generally urged to look at and consider federal registration of that mark, because that's a very broad right compared to common law rights. So registration of a trademark. Basically, what to expect. In general, an attorney will conduct a search, or a service will conduct a search for you. And what that search does, it's several $100, maybe up to $1,000. But it's a quick search of, or it can be a very thorough search depending on how much you want to spend. But it's a search of other businesses and uses within the United States, and it can be around the world, of the mark that you propose to associate with your product or service. And it comes back out and it returns to you with results that can be compared and used by the attorney to determine whether registration of your particular mark is appropriate for a particular class of goods. And there are sometimes the same word marks that are associated with products in different classes. An example would be, for example, the mark Dove, D-O-V-E. We know Dove soap, but if you looked and searched for Dove, there'd also be Dove chocolate. And it's been determined that Dove soap is in a class significantly different than chocolate, that there would be no confusion as to the source of Dove soap versus Dove chocolate. No confusion in the eyes of the consumer. So, again, the question, do I register my mark or not? Really, you need to consult with an attorney to answer that question. If one is building a brand around a particular product or technology, it is certainly a question worth considering. The issues and topics that will be considered will be the pluses and minuses of federal registration, as well as and the common law rights that I discussed. One other topic, just to close out this, well, there's two other topics. First is there are certain marks that simply are not registered, cannot be registered. One of the common examples is the mark cocaine for soft drinks. Coca-Cola has a strong mark associated with soft drinks, and cocaine is very close to that. And people have tried to use that phrase associated with soft drinks, and the U.S. law just basically says that's a bit too scandalous. Scandalous is a word that basically means it simply cannot be registered. Also, very confusing marks like merino. You've seen merino wool many times, but if someone attempted to register such a mark for nylon or linen or some other fabric, that would not be appropriate. And finally, just to round out the discussion of trademarks, its duration is as long as it's used. So in contrast, I didn't mention this, but patents under the law typically last around 20 years from the filing date. There are rules that cut that short a little bit or maybe extend it, but basically 20 years. And here in a trademark, it lasts as long as it continues to be used. And there are some traps and things that can happen. One can lose it by failing to police a mark or allowing a mark to become so descriptive that it actually describes the original product or service intended. And examples of that are aspirin. The word aspirin actually first started out as a mark. It was created, but it became so widely used as a descriptor of the product that any distinctive character of the word aspirin was lost. I believe the same thing happened to the word escalator, and the word Xerox was under threat, I believe, of being used almost as a verb to go Xerox something, meaning to go copy it on a photocopying machine. But Xerox has policed that enough to the point where I think it now has been saved and maintained as a mark to mean the Xerox brand of copying. But that is a potential problem with trademarks, so it must be policed. Trade dress. Trade dress is something that really protects the look and feel of a product. If you think back to the initial examples that I gave about the sweeteners, there was a pink package for Sweet and Low, and that's distinguished from the more bluish package of Equal. And regardless of the different chemicals that are in there, the different sweeteners, a consumer again may just associate his or her preferred sweetener with the pink package or the blue package. And that's a trade dress. It's distinctive, and it's not really functional. It doesn't tell you what the sweetener is. You have to look deeper. But yet, a consumer would associate the taste of the pink package and enjoy that better than the taste of the material in the blue package and choose it on that basis alone. That is something that's protectable. Again, there are some statutes in the United States. One is called the Lanham Act that has laws that help protect that, and there's also common law that helps protect these things. There's also another concept called dilution of famous marks that I want to just bring to your attention. Here is the cocaine example again, but also Coca-Cola on shoes. Coca-Cola is a soft product. It's a soda product, soft drink product, and it's not associated with shoes. So someone could say, well, I'll take the phrase Coca-Cola and make Coca-Cola shoes. There is a area of body of law that protects against the misuse of that. It's called dilution law. And even though Coca-Cola chooses not to use its Coca-Cola mark and associate it with shoes, it can't prevent others from using that mark in the shoe category because it would dilute the strength. The use of that, unauthorized use of that mark, would dilute the strength of the Coca-Cola mark. And so there's a protection for that as well. There's also a design patent, which is something that I want to bring to your attention. Design patent is different than the types of patents that I talked about. In general, the patents that I spoke about earlier are known as utility patents, and they describe an innovation or its function and so forth. Here, a design patent really is something that is non-functional, but it is protected for its aesthetic view, its design. And a good example is the Apple iPhone or iPad. The profile of those products are subject to design patents, and those design patents are examined in a similar way that I discussed earlier for novelty and non-obviousness and so forth. And they're not really, the concept of design patent is it doesn't have a function to design. The design is aesthetic as opposed to having a particular function. And these patents can also be exclusionary to others and then can be infringed. And actually in the Apple versus Samsung litigation that's going on in San Francisco, you may have heard about it, $1 billion awarded in damages by the trial court, whether there's an injunction. There are design patents involved in that litigation as well as utility patents. Design patents are a little less in term. They're basically protectable for 14 years from the date of issue. They may have longer terms around the world, and for instance, the European community protects them for 25 years. What types of designs are protectable would be furniture, tire tread, maybe a carnage components, bottle. Again, the shape of the Coca-Cola bottle is very recognizable and can be protected by a design patent if so chosen. Okay, finally, copyrights. So what are copyrights and how do they compare? Well, a copyright is really a protection of the expression of an idea, but it doesn't protect the idea itself. So what does that mean? That means if someone has written a song and writes it down or plays it, those are expressions of the idea, or records it, there's laws that protect it. If someone writes a slogan for advertisement, that's protectable under a copyright. And it usually applies to literary, artistic, musical, sound recordings, AV works, but it also reaches now to computer programs, architectural works, manuals, and these are also intellectual property rights that can be licensed and can be associated with innovative products of the type that we deal with today. So here's a list of aspects of copyrights. I don't want to go into the bullet points. I think, though, two important concepts that I want to raise to your attention is copyright is a statutory right, but it's based on originality as opposed to novelty, which I discussed in patents. And there's a difference between the two, and it's this. To be original means it has to be your expression. It has to be the expression of the applicant. To be novel, it has to be your expression, but also you have to invent it. You have to be your expression. But if someone else created it before you, that expression is not novel. In contrast, if one person creates something and expresses it, and another person similarly creates the identical thing in a different area and expresses it without knowledge of the other, both are original to those individuals, and both of those original creations are protectable. So the difference between originality and novelty is the fundamental difference between copyright and patent protection. The second difference worth noting is the duration of copyrights is significant. It can be 95 to 120 years, depending on when the copyright or the work is published, which is much more significant in length than the term of a patent, as I've discussed. So here is a copy of a copyright application, rather. It's really quite easy to do. It's a simple form that you can obtain, and you can work with a patent attorney, or actually you don't need a patent attorney, just a regular attorney who's familiar with this work and can guide you through this, or you can do it yourself. And you fill it in, pay a fee, and copyright is registered. Registration does not grant you the rights. Actually, according to the law, once one person expresses an idea, the copyright vests in that expression the moment that idea is manifested in some way. This registration process gives you, or gives the copyright owner, more rights, including the right to enforce it in court of law. There's also international recognition of copyrights, like the patents. There's a convention. It's called a convention, but it's basically a series of treaties that one can use to gain worldwide recognition and protection of copyrights. So, in summary, we've talked quickly, but hopefully I've given you some background about the different types of intellectual property that are available, including patents, design patents, trade dress and trademarks, confidential information such as trade secrets and know-how, as well as copyright protection. And I thank you for your time and attention. And if you have any questions, I'm happy to take them now.
Thank you very much. And I would like to remind our audience, if you would like to ask a question, you can select the Q&A tab, type your question by selecting Ask New Question. And while we wait to see if any questions come in from our audience, do you have any closing comments?
Nothing more except to say that when I know some of the attendees are to this conference are involved in startups and may or may not have some preliminary experience with intellectual property, I think it's one of the many components that you have to deal with in trying to bring an innovative product to the marketplace. It's not the exclusive component, but it is an important factor that you need to put into your portfolio of assets and things you need to do in order to get your innovation to the marketplace. So please pay attention to it and make sure it has the proper balance as your business moves forward.
Great. Thank you very much. And we have no questions at this time.
With that, Teresa, this is Jeff Whittle again. I'd like to turn it over to Linda Chow. Tom, thank you. That was outstanding. And now that we've had the kind of basics and fundamentals of IP kind of communicated to us, we'll now turn it over to Linda Chow with Stanford University to communicate to us, instruct us on commercialization and licensing of the IP, once it's kind of identified at that stage. Linda, would you like to proceed, please?
Well, thank you, Jeff. Well, it was a great presentation by Tom, so it really sets the stage of what is IP. So this session will be talking about what is licensing and why do it. And it's my pleasure to offer this session. I've really enjoyed working with the startups here at Stanford and also through the LES Foundation Graduate Student Business Plan Competition. So there's a lot of different perspectives that we can provide here. So for the So for the overview of this particular session, here are the topics. We're going to be looking at it from the different perspectives. For example, the party owning the rights, for example, all the rights that Tom described earlier. As the licensor, what are some of the aspects in terms of what's in it for me, why should I be licensing out, what am I licensing, and what else is there I need to consider. At times, I'll also put on the hat about the licensee, the one who's getting the rights. Why are we licensing it? What am I getting? What is there things to consider? All of this will play into the licensing game that you'll be taking part later in the month. We're going to be covering a lot of different terms. So what I do want to highlight is that the LES USA and Canada has put out a booklet on basics of licensing. So at the bottom of this slide, there's actually the link for that particular booklet. So looking at the basics of IP commercialization, we talked, as Tom mentioned, there's a lot of IP property rights. It's enforceable rights. So if I focus in on patents, patents is a negative right. So as the patent owner, I can prevent others from making, using, and selling. So basically, I have a big legal stick to prevent others. So what's the best way for me to commercialize this IP? So here are the possible approaches. So I could just use it internally for competitive advantage. And this is what happens often in the pharmaceutical industry. For example, a pharmaceutical company may patent a drug, take it through FDA. And so because of that patent, the pharmaceutical company can prevent other companies and any generics from entering into the market. So during the patent life, only that pharmaceutical company can sell that patented drug. Another approach could be a joint venture. I could be a battery manufacturer here in the U.S., but I want to be able to sell into Asia. So I would partner with either a Chinese company in which to potentially offer hybrid vehicles in China. So the U.S. battery company enters into a joint venture with a Chinese automaker. Most of today's discussion will be on licensing. So I think many of us have great TVs which have the Dolby sound. So Dolby has actually had a great licensing program where they develop a lot of technologies and then they license these technologies and their brand name to various manufacturers like Samsung. So if you look, you can see that it has Dolby surround sound on it. And so actually Dolby is licensing both trademarks, patents, know-how, copyrighted works. Another way that you could actually commercialize IP actually is to sell off the IP. Last year, Kodak sold off their digital imaging patent portfolio to a consortium of companies. So it's a complete sell-off. So basically you're losing control and another group actually is now the owner. Another item is you can securitize it. So basically you can get cash up front for a valid royalty stream. This has been done a little bit in the pharma area, but it has not been that popular. So for most of today's discussion and for the rest of this seminar series, we're going to focus in on licensing. I know this group is very interested in the Clean Energy Challenge, so I wanted to provide a sample timeline for a startup. So typically, the startup would first start off with an option agreement with the university. So basically, the option is used to reserve rights in the invention while the startup evaluates the technology, explores funding opportunities, and raises the capital needed to fully license the rights in question. So option agreements are typically short-term, 6 months, 1 year. It's a really fast agreement, and it's kind of basically just setting, I'm reserving rights. Once they raise funding, have a more developed business plan, at that point, I typically start negotiating a license with that startup. The license takes a little longer to negotiate because there's a lot more terms and conditions, both financial and non-financial. And we can talk more about it later on in this session about that actual license agreement. Once the company has started developing the product under the license, they also then have IP in which they have the university IP and their own IP. So given this portfolio of IP, how best to commercialize this IP? They could be like the big pharma company and basically just use it for their competitive advantage. Or they might want to enter into Europe and do a joint venture. Or potentially maybe they'll sublicense in a different market. For example, maybe they have an optical component which could be used for medical imaging, but it also could be used for displays. So maybe they focus on the displays and they sublicense into optical imaging. So there's different ways that a startup can approach it. So from this sample timeline, you can see that a startup at the beginning is the licensee, but over its lifetime can become the licensor. So it's actually really important to be able to understand the different perspectives from the different parties, because the more you know about being in the other party's shoes, the better you can come to a win-win type relationship. So let's get into licensing. So basically, we're looking at a controlled invasion of the licensor's rights. So the licensor, for example, is the patent owner. So as the owner and the licensor, I am going to give a part of the rights to another company. So what does this mean? So in licensing, in terms of layman terms, you have basically the licensor granting a right to use certain IP. It could be patents, trademarks, copyrights, that enables another party, the licensee, to use that IP under certain conditions in return for some form of compensation. So all the rights can be provided or some of the rights can be provided. And we'll talk about sort of the different scenarios there. Franchising is a type of licensing, but in the U.S. is subject to U.S. state law. So we're not going to talk about this in this particular seminar, but we're going to focus on more patent licensing, copyright licensing, trade secret, trademark. So in terms of a license agreement, I see it as a business contract. Tom provides a great legal perspective. I provide the business perspective. And what you'll find in terms of a license agreement, you need both perspectives. So in a license agreement, we're basically defining the relationship between the licensee and the licensor. So here's the typical parts of the agreement. I've seen agreements anywhere from like 10 pages to 20 pages or more. I like the shorter ones that are in plain English personally. So looking at it, we're focused on defining what is the license subject. So are we licensing patents, trademarks, et cetera? What kind of things are we licensing? What's the extent of the license? We'll talk more in later slides about exclusive versus non-exclusive, for how long, and field of use. We'll also get into some discussion about compensation. I'll do a high-level view. We'll actually have a session next week more on valuation. And then there's also other terms and conditions that can be incorporated into the license agreement. And so if we actually go to the next slide, the other provisions will address things about making sure we cover what both parties' interests are. I think there are certain areas that we are aligned, and there are certain areas that we can probably agree to disagree. We'll also be talking about enforceability of IP rights, different legal risk management, and the maintenance of the licensing relationship. The best way to kind of walk through these will actually be to look at an actual license. One of the things that is part of the licensing game is there is an example license. And also the startups here on this call, a lot of your universities have a sample agreement that's on their website. So you can kind of see sort of what are the different aspects. And I think you'll see that there's a lot of similarities between the example license in the negotiation game as well as what's at the local university. And we'll talk at the end a little bit more about what's different between a university company negotiation and a company-to-company negotiation. So why do we license? Here's just some of the reasons. A lot of it depends on the industry, on the company, on the particular invention, and on the business opportunity. But some of the things that do come up is that as a small company, you might be great in R&D, but to commercialize it to the next level in terms of manufacturing and marketing, you don't have that capability. Meanwhile, there's another company who actually does have the manufacturing and the marketing, but doesn't have the R&D. So in that case, there's a good partnership created between the licensor and the licensee. So another reason that a licensor might want to license out is in terms of they spent $1 million on this particular product. So how can they recoup those expenses? So for example, by licensing out, they can then generate revenue that they can use to create other IP. So there's many different reasons, and I think part of the discussion when you meet with the licensor and the licensee is to figure out what each party's interests are. From a university perspective, I'm looking for a party to commercialize the technology as quickly as possible and as broadly as possible. And then from the big corporation, maybe they're looking for, if they're working with a small bio company, they're looking for a product line to be able to kind of add to their drug platform. So there's different ways, and so there's no one answer. So what are the different things that can be licensed? Tom has already presented many of these items. In some cases, you might be only licensing one item. For example, in electronics, you're likely to just do a bare patent license. So all you're licensing, here's the patent. I give you the right to be able to use it in return for compensation. If you're in the chemical industry, you're probably bundling patents with know-how. If you're in consumer goods, you're probably doing a mix like Adobe, which has trademarks, copyrights, patents. And actually, Adobe actually has a really strong trademark program. If you're in software, a lot of copyrighted software, some trade secrets maybe with the algorithms, especially if they're not published. It could be patents as well. So what's the package? In some cases, it could be one thing. In other cases, it could be any combination of it. So this gets into what may be licensed, and this actually gets into the license agreement itself. So from a university perspective, we typically do bare patent licenses. We're just licensing the patent as is. But once the company, the startup, further develops it, they may actually be licensing a package to the larger corporation. For example, they'll be licensing this university IP that they have a license to. They'll add their own IP. They might add copyrighted software. So along the way, this package keeps growing. And as you look at that whole sample timeline, also think about the relationships between the startup to the university, but also the startup to the large company that you might be working with long term. So in terms of the scope of the license, we're talking about, for example, is this going to be exclusive or non-exclusive? So for exclusive, that means only the licensor is able to practice this technology except for certain conditions. For example, maybe the owner says, I want to reserve rights for my own use, so it's exclusive but for my purposes. It might be exclusive where it says in a particular field. For example, I might restrict it and say, you're exclusive in digital imaging. Or I might say you're exclusive for batteries for cars, but non-exclusive for the grid. So there's different ways that you can do this exclusive. In terms of non-exclusive, this is where several companies may use the same technology. And if you're looking at basic research tools, this typically is non-exclusive, and so that more people can actually use it. So from a university perspective, one of Stanford's famous licensing programs is in the biotech arena, which had to do with recombinant DNA. We made a conscious decision to license that non-exclusively so that more parties could actually leverage the technology and that it really helped to foster the whole biotech industry. So there's going to be different trade-offs that a university will make as a licensor, as a startup. You also will decide whether you want to do exclusive or non-exclusive to the next company. And there's different ways you can also break it up. Maybe, as I described earlier, by field of use, but it also could be by geography. For example, maybe you're saying, I will give you exclusive in Europe, but here the rest of the U.S. is non-exclusive. You might be able to divide by product line for a particular area. So like for this product, you can have exclusivity, but the future product, you don't. It also could be limited by time. I think from a university perspective, in the past, we've looked at the earlier of 8 years from effective date or 5 years from first sale. The thought being that that was enough time to have the licensee make a reasonable profit, and then it opens it up. But all of that's to be negotiated. What makes business sense for the two parties, both the licensor and the licensee? And a lot of times we do spend time discussing this. You have two sides. Of course, the startup, when they're working with the university, wants to do as exclusive as possible for all the fields and for as long as possible for the patent life. On the university side, is that a good use of getting the technology commercialized? Can that